Mr. Chairman and committee members, thanks again for the opportunity to speak to you today. I was just going to say second verse, same as the first, but I have a little bit more to offer, I hope, than just a repeat of last time. And you know my objections to the insurance exchange, so I'll concentrate specifically on House Bill 248 and talk about some of the problems still remaining with the bill. On page 3, at the bottom of the page in subsection 11, dealing with premium rates charged by health carriers. Now, bear in mind that under the Affordable Care Act, you can put in place rating areas without having to create an insurance exchange. So it's a fallacy that under a federal exchange, you couldn't have rating areas created. I'd also add that by referencing directly the Affordable Care Act, 42 U.S.C., you have a bit of a problem in that you're delegating the legislature's lawmaking authority to Congress whenever that law change so to your statutes. And that's easily remedied by simply putting in there the code section as it existed on a particular date, such as January 1st. I'm still very concerned about the assessment of fees in 416105C, that's on line 9 on page 4. You do have the ability to set some kind of rate in, and you should. In the course of the testimony in committee on Senate Bill 1042, you were told, I believe, that the rate was going to be $4.88 per patient per month. During the debate on the House floor, I heard somebody say the figure is now $7 per patient per month. So if you don't put something in there, I guarantee you the number is going to inflate and you will have no control over that. And theoretically, I mean, if the legislature can't control the rate, then arguably having the legislature come back and review the rate isn't going to do you any good because you'll just be told you can't do anything about the rate. That you're being told that because it's an independent body, corporate and politic, you can't do anything with that. I point to you 415506, which is the individual Idaho Individual High Risk Insurance Pool, in which the way in which the rates for the high risk insurance pool is calculated is very well defined. It doesn't have a dollar amount in there, which would be my preference. However, the formula under which the rate is calculated is set by statute. In addition to that, the rate is subject to review by the department director, Department of Insurance. So you do have the ability to revise the current bill in front of you and put some limitations in place. Going to page 5, the top of the page in the sub G, where it talks about before taking application, the director will receive a certification that says the personal information contained will be secure. Well, what we wanted something specific that said the information can only be used by certain agencies. There's a reason why the Tax Commission can talk to the IRS, for example. In Title 63, the Tax Commission is given the authorization to talk to the IRS. The only way for that transmittal of information to take place is through statutory authorization. That's what we wanted to see. We wanted to see some kind of limitation on which agencies would have access to the data. Federal or state agencies would have access to the data that's in the Health Insurance Exchange database. And I'd also say that by putting language in here that says the data is secure, you have created a bullseye, a nice big target for hackers, because once a government agency says their database is secure, I guarantee you somebody's going to be looking and saying, I wonder how I can prove that it's not. In sub I, there is a provision that talks about, let me back up a second. Sub H, dealing with the firearms and ammunition, that was required under a state insurance exchange. The reason it is because under the Affordable Care Act in section 2717, it specifically says that the secretary cannot cause the collection of information relative to ammunition and firearms. The secretary, however, there is something of a gray area with regard to whether a state creates an insurance exchange, that insurance exchange could be used for the gathering of this kind of data. So adding that provision, I think, was necessary, but makes it a bit net neutral when it comes to the issue of the Second Amendment. Regarding the portion where it says that if a section of the Affordable Care Act is ruled unconstitutional, then the exchange will immediately cease enforcing those provisions. Well, that's very, very vague. And that leaves it to the discretion of a court, and what that ends up causing, again, is a delegation of the legislature's lawmaking authority. And right now you're thinking that those court rulings will be beneficial to Idaho in some fashion. You don't know if that's true or not. And in fact, maybe a court will say that 2717, which I just spoke about, is unconstitutional. So does that mean the insurance exchange is going to start immediately gathering data on people who have firearms or ammunition in their homes? I don't know, but you don't know either. So I think you've kind of created a bit of an oddity there. Bottom of page 5, with regard to the fullest extent practicable entering into contracts with businesses located in Idaho. I think that sounds really good, but what that is really a manipulation of the free market and causes for an increase in cost to the consumer potentially. When you have a government entity that is supposed to be executing on federal and state laws, you want them to secure a product for a minimum cost, and you're just going to be passing that cost on just because the contractor happens to remain in Idaho. I know the intent is supposed to be a good intent, but I think that causes some significant problems. And finally, this is part of the old bill, but it didn't occur to me actually till this morning that this might be a concern. If you go back to page 3, and in sub 6A, where it says, neither the members of the board nor any person working or performing services for the exchange shall be considered public officials. I'm not quite sure what that means. I think I know what it means, but I think I know what the intent is. It goes back to that argument about the exchange not being a government agency. Unfortunately, however, in terms of public officials, under the Idaho Public Records Law, information concerning the pay of public officials is a matter of public record. But when you've said that they are not public officials, I'm just a little bit concerned that you will be exempting any employees who are hired by the insurance exchange as it pertains to the Idaho Public Records Law in 9340C. So again, to summarize, our objections regarding the insurance exchange haven't changed. I think this bill actually in some ways makes things worse. And at minimum, you should continue the pursuit of putting some sideboards and amendments on this legislation if you choose to move forward with an estate insurance exchange. With that, thank you again for your hospitality. I'm happy to answer any of your questions.
Thank you, Mr. Hoffman. Are there questions for Mr. Hoffman? Apparently not. Thank you very much.
Mr. Chairman of the committee, thank you once again.
Thank you.